Hey, mambo ni mengi.
Mambo is mengi.
Now, yesterday, Justices Frida Mugambi, Eric Ogola, and Anthony Mrima, after hearing all sides in this particular application, said, we are going to give our judgment. And they started and said, this is long. It is 500 plus, 300 plus pages. So just bear with us. Be patient and listen to the reasoning of the judges. In the end, the overall outcome of it is that Rigathi Gachagua's impeachment has been upheld. But there are several applications that have been taken before court by several people. And they just want to understand, what does this mean? So that we see what next for Rigathi Gachagua. What does it mean when the judges have said this and the other? What grounds would Rigathi Gachagua, for example, the lawyers have said we are going to appeal, what grounds would they be appealing for? And what would be the advisable application and plea from the Court of Appeal to say? The president of the Law Society of Kenya, Charles Kanjama, is here as our guest and is going to walk us through all that. Mr. President, good morning.
Good morning, Latif.
Karibu sana.
Thank you, and I'm happy to be here with yourselves and your viewers.
Asante. Now, Felaris is going to welcome you with the day's quote. Of course, you know the drill. Give us your thoughts on that quote.
Absolutely. Karibu sana. Today's quote is courtesy of Ali Mazrui. And we all know who Ali Mazrui is. One of Africa's most influential public intellectuals. And the quote reads, "The first responsibility of thought is not agreement, it is understanding." The first responsibility of thought is not agreement, it is understanding. How does that speak to you?
The first thing we need to do is to seek the truth, and the truth should be what unites us, not to seek unity at the expense of truth, but to seek truth, because we have been built or designed with an intellect that pursues the truth, and the truth is what can bring us together when we have a common understanding about the things around us.
Yeah.
Wow.
Truth.
That's a good
Truth.
one. Seek truth first, then unity comes.
Then unity later.
Correct.
Not unity.
Then
or
truth.
At the expense
at the
of
expense
truth.
of truth.
Quite
That's
like
a beautiful one. So, Charles, this matter before court, let's just start from the very basics. We know Gachagua was in court.
Yes.
Okay?
Yes.
Gachagua went to court to
Yes.
challenge his impeachment.
Actually,
Who did he take to? Who was in this particular case?
Actually, the interesting thing is, Gachagua went to court before he was impeached, in anticipation of the impeachment, when the proceedings were at the National Assembly. And he was told that, don't worry, even if the National Assembly decides to impeach you, which is the first stage in the process, you will still have a relief. Then he went back to the court after the National Assembly had impeached him, now before the removal, that is the impeachment proceedings by the Senate, because it's a two-stage process. And the court again told him, don't worry, even if the Senate removes you, we can always reverse if we find the decision to have been unconstitutional.
Yeah.
After he was removed, he went back to court. So you see, there were several cases that were consolidated. The one of after he was removed, the one of before his removal in the Senate, the one of before the impeachment in the National Assembly. And the cases were filed not just by Rigathi Gachagua, but several other petitioners, interested parties who are concerned about the process. So those cases were consolidated. There was even a case regarding the subsequent election of current Deputy President Professor Kithure Kindiki by the National Assembly after nomination by the President. It was also added there. So all those cases were consolidated and they were brought before this three-judge bench to deal with the matters. So the three-judge bench had to deal with all those issues. And as we were listening yesterday, because most Kenyans were glued to the screen, we had the court systematically decide several issues. The first and most fundamental, some had questioned the jurisdiction of the court to review the outcome of proceedings in the Senate and the National Assembly. And they had said those proceedings are not justiciable, which means it's a political process, it's not open to judiciary review. And the court disagreed. They said this is justiciable. Anything done in accordance with the Constitution is justiciable. Then the team in support of Rigathi Gachagua argued that the grounds that were given in the famous impeachment motion of Honorable Mutuse were not, did not meet the standard. And the court then said that no, our job is not to do a merits review. Our job is not to act as an appellate court to the Senate. Our job is just to test the constitutionality of their proceedings. So now they said, we are not going to go into each of those grounds to see the merits, the evidence, but was that process constitutional? Then after that, now they started dealing with the various challenges to constitutionality, beginning with the question of public participation, both in the National Assembly and the Senate. And the court said, no, public participation was not a requirement in the Senate because for them, they were doing a trial. It was not a requirement during the election of Kindiki in the National Assembly, because that is an elective process. It was only a requirement during the process in the National Assembly of the impeachment motion of Honorable Mutuse. And then they said that it is not the quantity that matters, it is whether it has been facilitated and the quality. And they concluded that the process was okay. Then they went to look at issues regarding the process that was followed in the National Assembly. There's Article 145 of the Constitution that guides the Senate. The Senate. And also they looked at the process that guided the National Assembly. These processes are also found in the standing orders. There was contestation about the constitutionality of various standing orders of the National Assembly and of the Senate. This was tested by the court. The court said the standing orders are okay. Even the time limit of 10 days is okay. If, for example, in the presidential election petition, you have to deal with the case in 14 days. So they said 10 days is not necessarily too short. And then, of course, they cautioned the Senate. They said that reading the Article 145, the 10-day limit is the limit for the investigation by the committee, not for the entire process. While the Speaker of the Senate had assumed 10 days was the limit from start to finish, which of course is one of the reasons why they declined to give an adjournment to Rigathi Gachagua when they were now presenting the hearing before the Senate. And then there was a contestation as to the procedure under the Constitution. Is it mandatory to go through a committee, or you can turn the entire Senate plenary into the committee to deal with the matter? And Article 145 says that when the impeachment motion comes, it is considered by the Senate, then the Senate may form a committee. So the question was that word may. Is it mandatory or not? And the court did an analysis of the Constitution making history and various drafts and concluded that because there's such an elaborate process of the impeachment through the committee, the intention of the framers was that once the Senate does a threshold test to determine whether to admit the impeachment motion, then the next step, if they say yes, we are admitting, they must go through the committee. So then there is a very interesting analysis, incisive analysis that was read by Justice Mrima. And at the end of that analysis, they kind of like punted on the goal. When the goal is now open, the footballer is ready to kick the ball into the net. They suddenly just kicked it on the other side and made in a very short reversal. In one paragraph, they said, but the Supreme Court in a certain case said, Sonko case said, ABCD. But of course, the Sonko case was a case of governor. It did not relate to Article 145. But they then retreated and said, because of the Sonko case, our analysis will not proceed. So it was very curious and peculiar to us as the lawyers who are paying attention. So after doing that entire analysis, they then came to the most serious question, the question of right to fair hearing, because it is the foundation of all these processes in the Constitution for hearing, adjudicative processes. They must start with fair hearing. Chapter 4 of the Constitution of Kenya is the Bill of Rights. It has all the fundamental rights and freedoms. And of those 26 individual fundamental rights and freedoms, from Article 26 to 51, only 4 rights are stated to be absolute. They cannot be limited. And those rights are found in Article 25. And the first of those 4 absolute rights is the right to a fair trial. And fair hearing is part of the right to fair trial. So when the court then comes to analyze the right to fair hearing, it says that this one was violated because this gentleman, a former deputy president, Rigathi Gachagua, he fell sick, he was not able to come, he asked for an adjournment, the Senate recognized, acknowledged, they even wished him well, and then they failed to adjourn. They decided to convert the hearing from oral, which was what was initially decided, to written, saying we will rely on his written documents that is already shared before us, without giving a good reason. There had been a lot of contestation about this testimony of Dr. Gikonyo, renowned cardiovascular doctor, and his affidavit had been admitted in court. The court said that this affidavit was not present before the Senate. Even though it was very interesting, we had the drama of how he was called by President William Ruto, is Rigathi Gachagua there, that evidence would be of no effect in their determination. Basically, they were making their judgment, they were proving their judgment or proofing their judgment against challenge in the Court of Appeal. Because, of course, if they said that they had relied on the affidavit of Rigathi Gachagua, it would be a ground of appeal of the other side. But they said, no, we've not even relied on it. We are just relying on the evidence that was presented in the Senate. And we are saying even the submissions of Honorable Paul Muite, because he was the one who, you remember, very dramatically said in the Senate proceedings that Rigathi Gachagua is not here. Is not here. And I've been told I can't proceed without him. That was sufficient because it was acknowledged by the Senate. So the court then makes a finding towards the end of the judgment that the right to fair hearing has been violated. But after making that finding, this is where we as the lawyers got shocked. Because all the times when the court makes such a finding, right to fair hearing has been substantially violated, the consequence, the inevitable, inexorable consequence is you invalidate the proceedings. But in this case, the court did an analysis of Article 145 and said that the moment the impeachment ends, because the final phrase in that article is the president stands impeached, and it also applies to deputy president. The moment you lose office, you have lost office, you can't recover it. So they said now we have to balance between the finality of impeachment and the fact that we've made a finding that there was violation of the right to fair hearing. So they said we'll not reverse this issue of finality of impeachment. And they had already previously said that the process of election of Kithure Kindiki was okay. It did not need IBC. It did not need public participation. It was not particularly rushed. It was okay. So then they make the finding that no, we'll not touch the fruits of the impeachment as regards the the next deputy president in Kenya, but we will award compensation and a declaration, which is a formal statement by the court that your rights were violated. And then that's how they finish the judgment. Latif.
Sasa, thank you. Thank you very much for actually walking us through that. Because it's very important to set that context of people just to understand who went to court, when and why, and what did the courts say for those 9 hours. Thank you very much. I think let's just dwell a bit on this last one. Where you're saying, goal ndio hii, kipa amelala, yuko na mpira, Kadenga na mpira, shoot, Gabriel Magalhaes. Over the bar.
Well, I think this hour will just call it Wakili, a quick one.
Even I was to ask, now that we have said the right to fair trial was violated, the second bit of it is that an impeachment is final. Please explain what that means and where we derive that.
Actually, it was a quite curious finding because you remember 1-2 years ago when the process was going on, the argument of the lawyers of Rigathi Gachagua was that if the impeachment takes place, then it will be difficult to reverse. So please stop the process right now. And the court told them, no, don't worry. Don't worry. The court is always powerful to reverse anything. There's no action.
We got you.
That is impossible to Kopoa. And then now, yesterday, the court reversed itself on that fundamental issue.
Right.
And now said impeachment process is final.
It's final.
Which means you can only get other remedies. And the court said that some of the remedies you can get include declaration, compensation, or the court can craft other kinds of remedies, which in this case it did not craft, apart from declaration and compensation.
But we can't reverse it.
Yes, and of course the court did not even pronounce itself on the question of, you see, there are two fruits of impeachment. One fruit is the immediate one, that you lose your office and your dignity and your reputation and everything else. The other fruit is the consequent one, that once your process of challenging the impeachment is over, you are not allowed to stand for office again. It is political death in Kenya under the constitution. So the court did not pronounce itself on this second issue. We have been left as a legal analyst to now do our analysis while the court is silent. So there's confusion in the matter, and clearly that is part of the challenge. And of course, once the court said that the right to fair hearing is being violated, then the High Court, the powers of the High Court are found in Article 165 of the Constitution. And Article 165(6), Sub-Article 6 says that the High Court has the power to review the proceedings of any quasi-judicial tribunal or other body exercising a judicial, quasi-judicial power. And the courts have said that when the Senate is doing an impeachment proceeding, it is such a body. So the High Court has the power under Article 165. But in the case of the judgment of yesterday, the court basically said our power is limited because of Article 145. Article 145 does not expressly limit the power of the court in Article 165. So that is one of the findings that has like been an earthquake and has shaken us. It has shocked us and it has disappointed us as a legal fraternity.
We have to take a break, but I have so many questions. Exactly where you've left off is where I'd like to pick up on, because you said the judges were not dealing with the merits of the grounds for impeachment, but rather the procedure, the methodology, the all of that. Fair. And then now, turns out they did have, in your view, they did have the capacity to actually go into that. So why not? That's number one. Then two, is there no room where they could have found that, the process was not proper, was flawed. Therefore, the impeachment does not hold, but that does not also mean reversing it. Is there some middle ground there? I know.
There's a lot of questions there.
Right? And I'd like Charles to answer them in just a little bit. We are with the president of the Law Society of Kenya, Charles Kanjama. We'll be right back after this. Hashtag is Fixing the Nation NTV.
Fixers wanaongea hapa online on YouTube. Hamisi says, while I respect the court's decision, I am not satisfied with the verdict on Rigathi Gachagua's impeachment case. In my view, the ruling did not adequately address key legal and constitutional issues. Alex, how did the judges arrive at a 50 million shillings compensation for breach in Gachagua's fair trial to hearing? Do they just do a picky ponky and arrive at a figure of 50? Still, Mike the One, on Gachagua case, we witnessed 9 good hours of justice being butchered. True strength is not found in putting others down, but in treating them with fairness, kindness, and justice. Steve Okech, we all know the judiciary is paralyzed. What we witnessed yesterday was the president passing judgment. Kipruto, Gachagua has repeatedly said that he doesn't want to be reinstated, that he wants to be compensated for time not served. 50 million is very generous. Kikombe, I'm not sure I should be excited or worried about such precedent. In this case, can be used against a future president. Hata tama itafika one. Donge. Walela, once impeached, you are impeached. Even if the sentence is set aside, it doesn't remedy damage. For Gachagua, it's exercise in futility. Jimmy, acknowledgement was unfair, but kwa justice itabidi tumehold ama just the 50 million. Right? So, and so on and so forth. Right? So many people still commenting, and we shall read the comments as we continue with this case.
Someone said that the ruling was flawed, had too much English. You've never spent time in a courtroom, my friend. Or with wakili.
Too much English.
Hey.
This was a flaw. It was a public delivery.
Yeah. Every time we hear court proceedings, we learn new words and big words, and also an opportunity to learn about the Constitution.
Yes.
And just as we were going on break, I was asking Kanjama on a number of things that came from this judgment. One, and you could explain to us constitutional finality. What does that mean as far as this judgment is concerned? And also to anyone that would be coming in with the thinking of, if the Constitution is very clear about the irreversibility of this judgment, did we walk into this with a predetermination? We were just waiting for what then the orders were. And not so much what we were expecting, like a big win for Gachagua being that this is reversible and you can be reinstated. And also, was the court trying to avoid a constitutional crisis where would have Kindiki and also have Rigiji?
Okay, so first of all, the words used in Article 145, Sub-Article 10, is shall cease to hold office. Those are the words that the court interpreted to mean that it is final and irreversible. And in my view, this is the first such determination that any action done under the Constitution is final and irreversible even before it is subjected to determination by the court. Because all other actions that are done by the executive, the legislature, the judiciary, state organs, the levels of government, even individuals, are subjected to review and potential reversal by the court. So this is the first such action that has been elevated beyond the level of all other constitutional provisions where actions are subjected to the judiciary. And the question that we are asking is why? Because it is not stated expressly in Article 145. It just says shall cease to hold office. It is true that Kenya was staring at a possibility of a constitutional crisis of some kind if you have two deputy presidents in office. But the reason the court exists is to untie any Gordian knot, if I may use the phrase, that may arise from its determination. The court is made of wise men and women who are able to tell what is the consequence of deciding one way or the other, so they can clarify. If, for example, the court decided to reverse the impeachment of Gachagua, then they would then face the question and have to deal with the question of who is the deputy president. In the same judgment, they could have given clarification to Kenyans. They could, for example, have said that every act done by the deputy president who succeeded, Kithure Kindiki, is valid because the Constitution has a provision that says that when someone takes office, if their position is later challenged, it doesn't affect the validity of the acts that they did when they were in office. And then now would say, now from today, because we've declared the impeachment to be wrong, what is the status in regard to the office of the deputy president? So the truth is, the judges were not constrained in the orders or directions they would give about the position of the deputy president. What I said is that they punted on the matter once the goal was open, wide open, because the World Cup is about to begin. The goalkeeper had rushed out of the goal mouth and had tripped on himself and he had fallen. And the striker was alone with the goal and the ball at his feet. And then he kicked the ball to the other side, to the skies. So that is what happened in this particular case.
Which is why I was asking, is there any middle ground in between what we got, which was, upholding the impeachment, and not acknowledging that indeed there was flawed procedure or that this was improperly done, but not reversing the impeachment? Is there some middle ground? And I want to tie that back to the fact that, you've stated that these judges also, it's within their purview to deal with, in your opinion, the merits of the petition that impeached Rigathi Gachagua. Yeah. So is there room for this 3-judge bench to say, this was flawed, but there was merit in the counts for the impeachment. Therefore, he still stands impeached, even if I'm just thinking out loud.
Okay, so first let me say that I think the court limited the scope of its judicial review of an impeachment process when it said it cannot look at the merits, but only at the constitutionality.
Okay.
Because the courts have previously said that when they look at questions of constitutionality or questions of law, they also are meant to check whether the grounds of impeachment were supported by any evidence at all. They're not necessarily standing on appeal, but they can still check, was there at least a level of evidence that you'd say seemed reasonable. So that is one thing I would say, that even the analysis of the court on its scope when it reviews an impeachment process was rather restrictive. The second thing I would say is that there's a general doctrine that if the tree is poisoned, root, stalk, and branches, then the fruits of the tree are deemed to be equally poisoned. You can't save the fruits when you have declared the entire tree to be poisoned. So the moment you say the right to fair trial has been compromised, it means you don't know what kind of defense Rigathi Gachagua would have presented if he was given an opportunity. You can't therefore assess whether the grounds of Mutuse were met because there was no fair trial. So it means you have to discard all the findings that were made by the Senate regarding some grounds being merited. So in my view, there's no middle ground, and the reason there's no middle ground is because Article 25 of the Constitution says the right to a fair trial is absolute. It cannot be limited. So it means the moment you look for a middle ground, you're actually limiting the right to a fair trial. And that is why sometimes when one is judging, if you make a conclusion that gives rise to an inevitable conclusion, you must have the courage to make that inevitable conclusion. To use the analogy again, Latif, if you are the striker and the goal mouth is open before you, you must have the skill to usher the ball into the net.
Don't run away from it.
Yes.
So many questions coming from this, and it has my mind thinking, one, about what the court has pushed back to Parliament, which is creating a law that outlines clearly what the process of impeachment looks like, the political process aspect of it, because the court was like, listen, that's a political process. Ours is not to determine it. Ours is to bring, look at the constitutionality of it. What can we possibly expect from Parliament? Because it's not like we're going to expect another impeachment of a DP, but what Parliament now has, it could, there's surprises in this country, but so that we don't end up in such a situation again.
Okay, so let me premise my response by referring to a certain Justice Nobari Dagdale. He is notorious in Kenya's legal history because in the 1980s, under our old constitution, we had Chapter 5, I think it was, on the Bill of Rights. And there was a provision in the constitution that asked the Chief Justice to come up with rules for approaching the court. And people went to court to affirm their constitutional rights. And he ruled in a series of cases that because the Chief Justice had not enacted the rules, therefore Kenyans could not benefit from those constitutional rights. It is considered a very distressing judicial analysis. It is kind of like scandalous. And so any attempt by a court in the modern dispensation to use that kind of reasoning, to my mind, is actually quite unfortunate and even appalling. So for me, my approach is simple, and this the courts have said in some cases, that the failure to enact any kind of procedural law does not take away from your right to enjoy substantive rights or processes in the Constitution. It cannot be paralyzed.
Right.
It can't, yeah.
Also, to add to that one, in the 5th schedule of the Constitution, when the Constitution was enacted, there was a list of laws that were required to be enacted within 5 years of the passage of the Constitution. And they were expressly stated, and Parliament followed that checklist, and they enacted all those laws. There's only one law that is contested right now, which is the one on Article 100, affirmative action, because even though Parliament enacted it, the court said that enactment was inadequate. So when the courts now bring up other laws that are not expressly stated, in a previous decision, they said that a process of removal of a judge by JSC is challenged because there is a law that they expect to be there, some regulations, and that if they are not there, the High Court said you can't remove a judge. You're paralyzing the Constitution that Kenyans enacted in 2010 because of rules that you've now said need to come up. It is very unfortunate. And that is also what I feel the direction of yesterday's judgment was going. Even if Parliament does not enact a law, if Senate and National Assembly want to impeach a president or deputy president tomorrow, they cannot be limited because the Constitution gives them the right.
Correct.
So when the courts advise Parliament, it should not be like mandatory that if you don't do this new law, then you cannot exercise a certain constitutional right. But what the courts did in my, let me say, my positive analysis is they were advising Parliament that there are some procedural gaps. There's a gray area, you could call it a lacuna, whereby it's not clear how the procedure should be undertaken for removal of a deputy president. It would help if you enact a law, an act of Parliament, or clarify in the standing orders to avoid this debate recurring. But the danger is always that even when you pass a law, that law can still be challenged as unconstitutional by a subsequent petitioner and a subsequent court. So enacting a law is not a panacea. It's not like a medicine that solves the problem, all the problems. It just helps to clarify. But fundamentally, what is in the Constitution should suffice at the fundamental level for any citizen, any state organ, any public officer who wants to carry out some functions that are governed by the Constitution of Kenya.
I like that.
I've listened to you, Charles, and my understanding of what you're saying is this one reason that was brought out by the court, that Gachagua did not get a fair hearing.
Yes.
His constitutional right to fair trial was not upheld. That is sufficient to actually have said this entire thing should collapse. Impeachment, right?
Yes. First of all,
and I want to base that on, even in the process of impeachment, the Senate had 9 grounds for impeachment.
Yes.
And they say 1 is enough.
Yes.
They can say no to 8, or 11 actually.
Yes.
They can say no to all the others, but 1 is enough.
Yes.
Are you saying this 1
Yes.
is strong enough to actually have, if they consistently went with their reasoning,
Yes.
that Rigathi Gachagua did not get his constitutional right to fair trial,
Yes.
that should have been sufficient ground,
Yes.
or would have been sufficient ground,
Yes.
to actually dismiss his impeachment?
Exactly. And that's
That one.
That's the interesting thing. During the impeachment, any one ground that succeeded was sufficient to impeach Rigathi Gachagua. During the court hearing, any one challenge to the impeachment process that was substantive was enough to vitiate the entire impeachment process. So that ground of fair hearing, that is such a fundamental ground. It's more important than public participation. It's more important than other aspects of procedure. It is of the essence, because I said Article 25 of the Constitution says the right to fair trial is absolute. Incidentally, we tend to use the phrase fair trial and fair hearing in an interchangeable way,
Okay.
but they are not completely interchangeable.
Oh, okay.
Yes. So the right to fair hearing is the whole of Article 50 of the Constitution. And then a fair trial is found in Article 50, paragraph 2. So it is an issue of analysis.
Perhaps begin with the difference between a hearing and a trial.
So
Just
when you look at the Constitution, fair trial tends to do with cases which are more of a criminal nature.
Right.
So you might be convicted of an offense. Then you have various fair trial rights. Fair hearing is any dispute resolution process in the courts, in a tribunal, alternative dispute resolution. All those is fair hearing.
Okay.
So fair trial is part of fair hearing,
Okay.
but fair hearing is bigger
bigger.
than
Yes,
fair
the
trial. That's
umbrella,
why
yeah,
it seems that we use them interchangeably.
Okay.
So Article 50 is titled Right to Fair Hearing. Article 25, when it says the right that cannot be limited, is the right to fair trial. But you see the proceeding in the Senate, because it was like a trial, and it was convicting Rigathi Gachagua of some offense, it's not just a fair hearing, it's a form of trial. But it is a trial in the Senate. So that is why, as lawyers, we are using the two terms fairly interchangeably, but you need to know they are not identical.
Okay.
Yeah.
Quick,
There's some big overlap, but they're not identical.
you talked about some of the other procedural issues, public participation being one of them, which is something we've struggled with because, one, there's no clear framework on what constitutes public participation. Now, is this something also that the court needs to pronounce itself on? And what parameters are used? Because if we don't have a framework, again, for what is considered effective public participation, then how can you say that public participation was done effectively? And this now, it goes beyond just the impeachment of Rigathi Gachagua and just about everything.
Okay. The phrase public participation or participation of the people, which is a similar phrase, appears numerous times in the Constitution of Kenya. Probably more than 5 times, maybe 7 times in different places. But the key place where it appears is Article 10 of the Constitution. And it is appearing there as a national value and principle of governance that applies to all persons, state organs, individuals, and state officers when they apply, interpret the Constitution, any law, or any policy. So it is a very broad principle. In regard to the chapter on proceedings in Parliament or Parliament, which is chapter 8, it appears in Article 118. It gives an even extra obligation to Parliament that in all its processes involve the people, because Parliament is a legislative arm or organ of government. Even when it does its oversight, it's doing it on behalf of the people. So Parliament is meant to integrate public participation in everything it does. And what has happened, because there has not been any act of Parliament or law establishing public participation, and the courts have urged Parliament to draft a law, the courts have been forced in a series of cases to start giving guidelines and principles to what public participation is. So there are cases in the Court of Appeal and the Supreme Court, like the BAT case in the Supreme Court, where they've analyzed public participation. And so Kenyans, including lawmakers, are now guided because the courts have interpreted this in various cases. Impeachment of Martin Wambora, the first governor to be impeached, impeachment of other governors, and other proceedings, laws, security laws amendment, everything. They have been analyzing what does public participation mean. There are principles, and I can spend some time, if we had time, explaining some of the basic principles of public participation. The problem we are facing is that the moment the finance bill judgment went to the Supreme Court, the appeal from the Court of Appeal, the Supreme Court kind of like reached the limit of expanding public participation and now started retreating. The first retreat was in the finance bill judgment of the Supreme Court, where they reversed part of the finding of the Court of Appeal about public participation not to be illusory, that you also need to consider the views of Kenyans. You can't just say, I give Kenyans a chance to speak. You are speaking like a radio and I'm not even paying attention. You must demonstrate
that you actually heard them.
Considered what they did. So now, these reversals to public participation are worrisome to some of us. And this judgment of yesterday was yet another reversal to public participation. For example, this public participation in the case of Rigathi Gachagua, you remember what was shared with the public was the petition or the impeachment motion of Mutuse. There was no sharing of the response of Rigathi Gachagua. So how do you engage in effective public participation if you hear the complaint but you don't hear the response?
The response.
But the court said it was okay. You see?
There's a lot. Even the way, I wonder even if they kind of raised the bar for public participation during that time, because the way it's done for any other legislation going through Parliament is very much citizen driven. I email clerk at Senate, unless someone does the work and creates like a nice little mini app. But this one, gazeti ilikuwa na form. Kazi yako tu ni kusign. And I'm like, what does this mean? And I had not even thought about that side. You're only hearing one side of the story.
Correct.
Fair. But then have they raised the threshold? I don't even have a question here. I'm just wondering if we're operating in some
out loud.
odd gray area and how we move forward. But we're running out of time, Charles. In your opinion, appealing, yes, will an appeal hold in the Court of Appeal?
What should the appeal be?
So there'll definitely be appeal. And the petitioners already said they're appealing. Some of them even said they had already filed their notice of appeal. In the course of the day, they concluded this judgment was not going to be in their favor.
Get ahead of it.
They were not happy about some of the findings. As the judges were reading, they filed the notice of appeal. The notice of appeal is meant to be filed within 14 days of the judgment. So the advocates are consulting with their clients. Once they file the notice of appeal, then they have an extra 60 days after the proceedings, the typed proceedings have come out, to file the record of appeal. And in the record of appeal, which includes as a bundle all the documents that were submitted to the High Court, one of the important documents, in fact, the two most important documents is the judgment of the High Court and then the memorandum of appeal. And the memorandum of appeal is what you could call the pleading when you go to the Court of Appeal. It contains your grounds of appeal. What are the reasons why you've disagreed with this decision? So when you are drafting a memorandum of appeal, you look at two basic documents. First, you look at the judgment that you are not happy about. And unachambua your judgment. You analyze it. You see what has been said that you disagree with, points of law, you raise them, and sometimes points of fact where you feel the court misapprehended the facts or the evidence and reached a wrong conclusion. The second important document is your principal document in the High Court, which was your petition. So many times you'll find parties revisiting the arguments that they had used in the High Court, crafting them now with reference to what the judges decided in the High Court when they are doing their memorandum of appeal. So we'll find all these arguments that the court dealt with when it identified the issues, which I started this session by taking you through some of the issues. All of them are likely to be revisited in the Court of Appeal. And the petitioners will be asking the Court of Appeal to find that where the court disagreed with them, like on public participation, on the fact that you must go through committee, can the Court of Appeal depart from the High Court, reaffirm those things? And fundamentally, now that the court agreed with them on the question of lack of fair trial, can they take the next consequence, which is to overturn the impeachment of Rigathi Gachagua? On the other side, those who were supporting the impeachment, like Professor Tom Ojienda was representing the Senate, they will be saying that no, this fair hearing, the court got it wrong when it said there was no fair hearing because of the adjournment. We gave him an opportunity. And the court had already said the affidavit of Dr. Gikonyo should not be considered. So we dealt with what we had. We had limited time. So them on their side, they'll be asking the court, the Court of Appeal, can you reverse what the High Court said, that there was no fair hearing, and just allow the impeachment to stand and even overturn the compensation that was given to Rigathi Gachagua. And then, of course, the court, after considering both parties, may also choose to either agree with them or even just to uphold the decision of the of the High Court in whole or in part. So that is the scope, the way forward, as this matter is proceeding.
As it goes on. Charles, I know you've got to leave, but I have a question, and it's at top of the hour. Can we do a break and then I can just ask you the question before we invite the next guests?
Okay.
Right? Because I want to understand why a senator is acting in court on behalf of the petitioner who's challenging the decision of the Senate.
Which is part of.
And then another senator is defending the Senate. You know?
Yeah.
I just want to understand that. Charles Kanjama, president of the Law Society of Kenya, is our guest. He is winding up, but just that one question before we go into seeking to understand the new tea levy. It's 8 a.m. Kenya. Right, so Charles Kanjama will be leaving us shortly, but Mr. President, before you leave, we see people who are acting as, elected senators, serving as senators, also going to court to act for several parties that are still challenging decisions of the Senate, and so on. In this particular case, we have Professor Tom Ojenda, who is a senator for Kisumu, who was representing the Senate in this trial. Then we have the other one, whereas Dan Manzo, the senator for Makueni, was also among the battery of lawyers on the applicant's side. He was basically, if we just look at the general, the name of it, he was challenging the decision of the Senate to impeach Rigathi Gachagua. Now, a senator challenging a decision that he participated in to impeach, another senator defending a decision that he participated in to impeach. How is that? How do we draw that? Where do we draw the line?
Okay, 2 or 3 things I could say. One is that when Honorable James Orengo, who's currently governor, was a member of parliament, the question arose of whether parliamentarians, members of parliament, who are professionals like lawyers, could represent parties in court. And the court determined that issue and said that there was no restriction apart from if there is a direct conflict of interest in lawyers who are MPs representing parties in court. So that issue was resolved. So then the second question is now, what constitutes conflict of interest? And if you are, for example, the chairman of a public accounts committee, and then as a result of your role as a chairman of public accounts committee, you get to know certain information, you ask certain questions, can you now take a position that is opposite that one? In this particular case, however, because it was an impeachment trial and each senator voted and they did not all vote the same way, and it was a public issue, in my view, there is no limitation to one senator taking one position and another one taking another position. Of course, the Senate itself as a body must take a position in support of the process and the outcome it undertook, unless it concedes that the process was faulty. And that is why they instructed Senator Ojenda to represent them. But Senator Manzo did not need to agree. And even during the proceeding, he disagreed with the process. He voted against the impeachment, I believe, so he had a right to come and even express his position to the court.
Fair.
Okay, understood. Someone is asking, Felix is asking, ask Kanjama, we've seen the Speaker and the Deputy Speaker of the National Assembly publicly declaring their position and support for the impeachment. Is that right?
If they declare after the event, that is one thing. Before the event, I think it then starts raising questions about their impartiality. And that is one of the issues that was before the court, whether the speakers of the Senate demonstrated impartiality or fairness. The court concluded that there was no substantive evidence that they were not impartial, and also that members of the Senate, as politicians, sometimes can manifest political positions But so long as when they hear the case, they are able to focus on the facts of the case and the standard of the case, that should be okay.
Yeah.
So that is what the court concluded. Whether rightly or wrongly, I leave that for another day. Eric, I have to leave.
Finally, as you leave.
Yes.
Right now,
Yes.
can Rigathi Gachagua vie for president, for public office?
Yes, so the provisions of the Constitution that deal with that is Article 99, 137, and 148. Article 99 is on qualifications of member of parliament. Article 137 is on qualifications for president, which says they must be qualified to run as an MP. And Article 148 is for the DP. It says the deputy president must be qualified to run as president, who must then be qualified to run as a deputy president, as an MP. So Article 99 is the most important. And then, of course, you have Article 73 and 75 in Chapter 6 of the Constitution, which talk about what are the qualifications for you to be elected into office. Article 99, sub-article 3 is the most important. It says that somebody who has been removed from office on the ground of failure to comply with Chapter 6 is disqualified from running again, but only after their process of appeal has been exhausted. So Rigathi Gachagua challenged his impeachment in the High Court, and there has been a partial success by the High Court finding that his rights to fair trial were violated. But the High Court left open the question of whether all the fruits of impeachment will still apply after upholding the finality of impeachment. But the appeal will continue to the Court of Appeal and the Supreme Court. So a plain reading of Article 99.3 shows that his right to vie for public office is still open, is still alive until such a time as the Supreme Court will give its final determination. If the Supreme Court upholds the impeachment, that is what will extinguish his right.
His right to
Wow.
vie.
Mr. President, thank you very much for joining us. Charles Kanjama is the president of the Law Society of Kenya. He's been taking us through understanding the judgment that came out of the High Court yesterday. We'll let you leave now. Asante.
Thank you so much. Thank you for inviting me, and it has been a pleasure to engage your viewers at this hour.
Asante.
Thank you.